Dear clients and friends, thank you for watching Tanner DeWitt's M&A series. I'm River Stone, a partner in the corporate department and head of the China practice. Today, I'm going to give a brief introduction to the due diligence exercise in a typical merger and acquisition process. On any acquisition, a buyer will want to be sure that the seller has good title to the shares of the target company and that the target company has good title to its assets and the business. The buyer will also want to know the full extent of any liabilities it will assume after the acquisition. Due diligence is the exercise of digging out information, liabilities, and the risks associated with the shares and the business of the target company by reviewing documents, making inquiries, doing public searches, and the various other activities. Due diligence is an ongoing process which could happen before the acquisition and continue during the acquisition process or even after the completion. The primary purpose of the due diligence is to obtain sufficient information about the target company's business to enable the buyer to decide whether the proposed acquisition is a sound commercial investment. Typically, there are three categories of due diligence. They are business due diligence, financial due diligence, and legal due diligence. Business due diligence looks at broader issues such as the market in which the business operates, competitors, the business strengths and weaknesses, the production, sales, and the marketing, and other issues. Business due diligence is usually conducted by the internal business team of the buyer or the business consultant engaged by the buyer. Financial due diligence should focus on the target company's financial conditions that are material to the buyer's decision, for example, assets, profits, liabilities, cash flow, and so on. By looking at those, the buyer can assess the financial risks and opportunities of the deal and whether the target business will fit well into the buyer's strategy. Financial due diligence is usually conducted by financial advisors or accounting firms. They may review the target company's audited and unaudited accounts, management accounts, bank statements, as well as underlying documents. As a lawyer, I will talk more about legal due diligence. Legal due diligence will typically focus on establishing the key legal issues affecting the target company or the business, including the legal obligations and the liabilities which the buyer will potentially be acquiring and any legal risk in the transaction. For example, if the target company breached a material contract, the other party may sue the target company. However, the litigation may only commence after the completion of the acquisition. Accordingly, the buyer may face the risk of spending costs to defend the case and even paying damages. For example, if the target company breached a material contract, the other party may sue the target company. However, the litigation may only commence after the completion of the acquisition. Accordingly, the buyer may face the risk of spending costs to defend the case and even paying damages. The purpose of the legal due diligence is to find out those potential legal risks and the liabilities so that they could be addressed in various agreements related to the acquisition. The key areas which are typically addressed in a legal due diligence include corporate structure of the target group, whether the seller has the capacity to sell the shares or business, whether the seller has a free title of the shares or business, historical corporate actions and the transactions of the target company, risk and potential liabilities under material agreements, financial arrangements, legal compliance and anti-bribery matters, whether there are material litigations affecting the target company, whether the target company has free title to its assets, intellectual property rights and information technology issues, employment and pension issues, tax issues, data protection issues. Legal due diligence is usually a lengthy and expensive process, and most of the documents and the materials need to be disclosed by the seller or the target company. Law firms need to be engaged to prepare due diligence questionnaires for the seller or the target company to answer. Lawyers may need to enter the offices of the target company to review the documents, meet the management of the target company, and ask important questions. Usually, a due diligence report will be prepared to list out clearly all the issues. The buyer can then make a final and sound commercial decision based on the result of the business, financial, and legal due diligence. However, please make sure you engage proper intermediaries such as lawyers, accountants, financial advisors to assist you in conducting due diligence. That's about all what I want to talk about today. Thank you for watching. Please also spend some time watching our other videos covering various legal issues.